Blessings, family. This is Noemi Soto with BG2G, and this is an intro to a series of videos that I'm going to be posting on Justice Diaries. And in case, for those who don't know, I am pioneering a justice advocacy initiative, which is not social justice. But in Justice Diaries, I'm basically going to be talking about my personal adventures with our justice system. So I am currently fighting a discrimination case in the Connecticut court system. It went from the Superior Court, from Middletown to the Appellate Court, and now I'm going to be taking it up to District Court. But I want to read a brief history of what this case is. I submitted back in October 2019 a motion for reconsideration and bank. This was after the appellate court, 3 judges basically dismissed my case and did not want to answer any of my legal questions. They basically want to ignore what I'm asking because they don't have a good answer for it. But they're very significant questions. And I basically called for all of the judges in the appellate court to rule. And I want to just kind of read this out, and then I'll take you from the beginning. But just so you get a taste of what this series is about, this is Justice Diaries, Christians Alliance versus Noemi Soto, hashtag BG2G. So the motion for en banc. Pursuant to Connecticut Practice Book 71-5, pro se plaintiff, meaning me, requests a reconsideration of case en banc to secure uniformity of decision, and because this decision implicitly diminishes judicial power, obstructs U.S. citizen rights to petition the courts, and defames the state of Connecticut's judicial integrity. As under brief history, I write, pro se plaintiff, me. I filed a civil suit in Middletown Superior Court for disparate treatment that was dismissed on the claim of lack of subject matter jurisdiction. Superior Court judge exalted an administrative remedy under the executive branch above constitutional law, judicial code of ethics, and partially deliberately failed to encompass a conclusion to each claim of law raised by all parties. Basically, what I mean by that is that according to the practice book, a judge is supposed to answer encompass a conclusion to each claim of law raised by all parties. And what the Superior Court judge did, basically, he completely omitted, denied, did not include any response to my side of the argument. He only acknowledged the defendant's side, and that's it. So it was partiality, absolutely, favoritism. He completely just ignored my legal question. So that's what that means. Or, as a matter of appeal, a memorandum decision was entered affirming the Superior Court judgment that omitted a written opinion and deliberately failed to address the statements of issues raised on appeal by pro se plaintiff. So basically what happened here was, when I appealed, I reiterated my question from that I asked the Superior Court that he didn't even acknowledge. I reiterated it, and I wanted a response, and I did not know that the Superior Court, the appellate, that they could just issue this memo that literally it just said judgment affirmed. Sorry. So basically they just said, okay, yeah, we agree, but they didn't explain any of the legal questions that I asked them, and that is a very big no-no. So yeah, so that's what that means. 5, under specific facts, I write, an administrative remedy under the executive branch cannot render impotent judicial power over a judicial matter apart from judicial discretion. So judges have discretionary power. That's basically according at their discretion, they can say or do certain things, right? And without getting into too much details, I'm basically saying that, you know, an administrative remedy is not above constitutional law, is not above judicial power, which was the whole emphasis behind lack of subject matter. They were basically saying, oh, we don't have jurisdiction to hear you or your complaint because you got to go through this administrative remedy first. But the administrative remedy is under the executive branch. Why would I have sought an executive remedy under the executive branch for a judicial matter? This is a conflict of separation of powers, because our Constitution clearly divides and allocates power to 3 branches of government, and they cannot intermingle. And even if they do, one cannot hold supremacy over the authority and job function of the other, which is what basically they said why they dismissed my place in the first place. So 6, judicial discretion is legally obligated under the Code of Judicial Conduct to uphold and promote the independence, integrity, and impartiality of the judiciary, promote confidence in the judiciary, and ensure the right to be heard. So I'm basically quoting from the Judicial Code of Conduct, which, and I say here, the Code of Judicial Conduct defines law to encompass court rules, statutes, constitutional provisions, decisional law, and the Code of Judicial Conduct. The ethical rules for judges is law legally binding on a judge. Not necessarily us, but on a judge, yes. And so one of their mandatory legal obligations to the public is to ensure the right to be heard. And what they've done from the beginning is they've dismissed my case. They don't want to answer my legal questions, which they have an obligation to do, and they just keep dismissing. So 8, Connecticut constitutional provisions state that all courts shall be open and every person for an injury done to him and his person, property, or reputation shall have remedy by due course of law, and right and justice administered without sale, denial, or delay. Basically, what they've been doing, they've been, you know, denying my right to be heard, and they've been delaying the entire process. I'm gonna talk in another, in the episodes to come, about how I issued a summary judgment, which, could have ended this whole thing in a lawful way, but because these judges don't want to answer, and I'm going to be claiming out names because this is all public information. All of the writings that I have submitted to the court are posted and up for view in my website, BG2GCT.com, under Justice Diaries or Justice Advocacy. Every judge has solemnly sworn that they will support the Constitution of the U.S. and the Constitution of the state of Connecticut, so long as they continue a citizen thereof, and that they will faithfully discharge according to law the duties of their office to the best of their abilities. I basically quoted this as a means to, trigger their conscience. This is actually their oath of office. And the fact that they are denying my right to be heard, the fact that they're dismissing, they're ignoring my questions, my legal questions, is not them faithfully discharging the office of their, the duties of their office. And then I quote another Connecticut constitutional provision: all political power is inherent in the people, and all free governments are founded on their authority and instituted for their benefits. This is, we know there's a swamp in government here in America, and these are the games they play that they've been getting away with because they can. This is just a little preview. I hope you stay tuned. I'm probably going to be filming this whole thing like in one shot, but it's like several hours worth, and then I'm going to break it up into series. So stay tuned. Justice Diaries. This case is Christians Alliance versus Noemi Soto, me, hashtag BG2G. And I'm going to be spilling all the tea on what this corruption, collusion stuff has been going on right here in Connecticut. All right. Blessings, fam. Stay tuned.